Hello, everyone. Joe the lawyer here. Welcome to my first episode. The topic today is going to be plea or trial. I want to go into some of the thought process and the discussions and the thinking that goes behind whether to take a case to trial or to take a plea. And that's in the criminal defense context when I talk about taking a plea. In the civil litigation context, it would be taking a settlement or going to trial. But before I begin, please subscribe, like, comment, and share this video after you have watched it. If you enjoy the content, it's a free way to support the show. It incentivizes me to make more videos. Also, I have a Patreon set up below. Any donations allows me to free up some time to make these videos because I'm a full-time practicing solo practitioner. Mostly I do criminal defense, but I do personal injury, employment law, family law, landlord, tenant, a little bit of everything. So before we begin, if you're fans of some of my other YouTube channels, you know I like to do a same time sip. Today I have the beverage of the gods, coffee, hot, fresh coffee. So today I want to talk about the decision-making process between whether to take a plea or settlement or to go to trial. I've come up with three factors that I believe most influence the decision-making process. Now, there can be more than three, there can be less than three. Some of these are even like larger factors that can be broken down afterwards. But the three that I identified as weighing the most are number one, the strength of the case, number two, the possible sentence, and number three, who the judge on the case is. Number one, strength of the case. And the way I sort of want to talk about this is through two cases that I recently had. I recently did a trial, a non-jury trial in a criminal case, and I won. And those facts, okay, were similar but different to a case that I recently took a plea on for my clients. And the key factor between me taking case number one and case number two to trial in this instance was the strength of the case. It sounds pretty obvious to perhaps many of you out there that, yeah, if you think you're going to win the case, you should obviously go to trial. And if you think you're going to lose the case, you should obviously take a plea. But it's a little more complicated than that. The reason it's more complicated than that, at least in the vast majority of cases, is that I do not have a crystal ball. My client doesn't have a crystal ball, and none of us out there, whether we think we can predict the future or not, are not Nostradamus. So every case, what I try to do is break it down into a cost-benefit analysis. I never tell my clients I can win the case. I know I will win the case. Many of my clients want to hear that from me. One thing that I will see is they will ask me, because these are individuals who are facing jail time, they will ask me the same question over and over and over again, hoping to get a different answer. Joe, are we going to win? Joe, are we going to win? And what I tell them is, I have walked into cases where I thought I was going to lose, and I knew I was going to lose, and I did a hearing or I did a trial on them, and poof, I won. Because trials are unpredictable. You don't know what's going to happen or what's going to come out. But by that same token, I've walked into cases I thought for sure I was going to win, and once the hearing began and we had the trial, boom, I lost. So it's impossible to predict. What I do tell my clients, though, is I say to them, I try to couch it in words of more likely than not. because I can at least look at a case and I can say, more likely than not we would win this, or more likely than not we would lose this. And I don't like to put percentages on it, but sometimes the conversations get so long that I do. Let's do same time sit. Hang on. So I will say, we have a 70% chance, it's about, I'd say it's around 70% that we could win. This is one of the things also, unfortunately, that clients hate about lawyers, is that we don't talk black and white. That's not a problem with lawyers. That's a problem with the world, reality, and human nature. The world is not black and white. The world is various versions of gray. Only at the extremes can you get black and white. And sometimes that's the case, where it's so extreme that I can say to someone, the evidence is overwhelming against you. There are instances like that. Or there could be a case where I can say there is zero evidence against you. But most cases are not like that. Again, this is the gray principle. Most cases, 75, 80% of cases are somewhere in the middle. So I have to give my opinions as somewhere in the middle. Those cases on the far ends are easier to evaluate the strength of and come up with a decision of whether to take a plea or whether to go to trial. So the interesting thing about these two cases that I had was, case number one, which I took to trial and I won. The facts were better. Our defense case was strong before we went into trial. And I told my client that. I think I told him it was around 70. I said, I think we got like a 70% chance. And that way, if we went in and we lost, he knew that there was a possibility that we would lose. It was a close call. The interesting thing, too, was when the judge made his decision, he even said it was really close. He said this was he said it was a 50-50 case, but in that circumstance, he had to go with the defense because of the reasonable doubt standard. So a lot of judges, if it's right in the middle, they lead towards the defense because reasonable doubt shows that the prosecution has to meet a very high burden. So in a toss-up, it should go the way of the defense, and that's what the judge did. Now, this other case, the facts were not as great, okay, and we ended up taking the plea, but I'll get more into that decision-making process on that case in a minute. So that's probably the number one biggest factor on whether to take the case to trial or to take a plea is how strong your case is. If you feel very confident about your case, you want to drive it strong to trial. Well, let me take that back. You should drive every case strong to trial, whether you're going to win or you're going to lose. But on the ones where the cases are really strong, if the tire hits the road, you're ready to go. You're going to go into trial. Sometimes you're playing a game of chicken where you are pretending that you have an extremely strong case in order to get the other side to make you an offer that your client will accept, even if your case isn't that strong. But that's a basic principle of negotiation, right? You almost always want to appear strong. If you read The Art of War, which I'm sure many of you have done, but a higher level of negotiation in that instance is what Sun Tzu says is when you are weak, you pretend to be strong. And when you are strong, you pretend to be weak. That way, your opponent can never truly know how strong or how weak you are. But if you pretend to be weak, but you are actually strong, then you can take the case to trial, you can win, you can surprise your opponent because their defenses will be lowered because they thought your case was weak. And the same when if you are actually weak and you are pretending to be strong, you drive the case strong in order to strike fear into your opponent and have them either not be ready, not be prepared, or to give you an offer that you want to take. So the strength of the case is the number one factor in whether or not to go to trial. And I'll say those cases that I had, this one, the facts actually were stronger. This case number 2, which we took a plea on, had some facts that were going to hurt it. Number 2 is the possible sentence. So before I go to trial with a criminal defendant, Pennsylvania has what's called the sentencing guidelines, which tell a judge what kind of sentence to impose upon a defendant if they are convicted of a certain crime. So I can take the guidelines and I can sit down with my client and I can tell them, look, this is what would happen if you go to trial. And, they may be facing 6 months of probation, 1 to 2 years in jail, 5 to 10 years in jail, 10 to 20 years in jail. They may be facing a life sentence. And of course, that's going to be a really huge factor on whether or not you go to trial. Just as big as perhaps as the strength of the case is the possible sentence. In the civil context, the sentence is, well, if you're on the defense side of civil cases, you have to figure out how much money you could get tagged for. You may say, oh, the most we're at risk for is $50,000, or the most we're at risk for is $2 million. That's a huge difference. So your decision making is going to be hugely different. But in the decision making process of criminal cases, sentences is usually huge, because there are some clients where even if they lose at trial, they may only go to get a probationary sentence or a very short jail sentence. So it may be worth it to take that risk, even if their case isn't that good, because like I said, you never know what can happen. The flip side to that is sometimes the prosecution has a weak case, but if your client is convicted, they could go to jail for an extremely long period of time. Okay, and that's what happened on this other case. Is my client on case number 2, where we took the plea, he could have possibly gone to jail for 10, 15, 20, 30, 25 years. It could have been an extremely long period of time. And the case against him, not as weak as this case I took to trial, but it was almost maybe a 50-50 case. So you want to flip a coin, all right, as to the strength of the case, it's 50-50. If you lose, you get 20 years. If you win, you go free. The stakes are incredibly high. What happened was this client ended up taking a plea for just a couple of years. And so he, in a sense, he gave up a couple of years of his life to avoid the possible bad consequences of 20 years. If that case carried less time for him, we would have gone to trial, because again, it was a 50-50 shot, and I would have loved to have tried that case, taken our best shot, but the risks were just so high. And that was the tough thing we negotiated, and I negotiated with my client. There's always multiple negotiations going on. The attorney is negotiating with the client, but the client and the attorney always show a united front to the prosecution and the judge. So it appears like the attorney is, doing all the negotiating, and the client is always on board. But what could actually be happening is the client and the attorney could be arguing the whole time, and the attorney could be trying to convince the client of one thing, and the client may be trying to convince the attorney of something else. But you always have to present that united front. Not always, but usually you want to present that united front to the court and to the prosecution. But that's also one of the reasons you want to have an attorney. Okay, because it can disguise your true thoughts. Whereas if you're a pro se client, which means you're doing a case with no attorney, the prosecution and the judge are going to be able to read you 100 times better. So those are the two biggest factors: the strength of the case and the possible sentence. When your client's facing a big sentence and the case is not that strong, there's a small chance of winning, and you go to trial. You got to have balls of steel, man. Anytime your client's facing that much time. In this case that I won, my client was likely going to get 5 to 10 years in jail. It's just an excruciating. It's high stakes. I mean, being a trial attorney is very, very high stakes, and the one thing my clients always say to me is they say, "This is my life. This is my life." I get to go home at the end of the day. The prosecutor gets to go home. The judge gets to go home. The victims in a case, and I understand that they're seeking justice and they may have been very, very much wronged, they get to go home at the end of the day. And nothing that happens in that courtroom is going to change the past. But the only person whose future is truly going to be impacted is the defendant, is the client. So I believe that that's a very heavy burden that criminal defense attorneys carry. The same is true in civil law sometimes. So let's get to factor number 3, the judge. And it is just incredible. Now this could actually fall under strength of the case, okay? Because who the judge is and who the prosecutor helps the attorney know, well, that's a really good lawyer. He or she is very good at these cases. That judge is more defense friendly. So those could actually be looking at the strength of the case. So, but it's such a huge impact, okay, that I put it as number 3. And in this case that I won, we did not do a jury trial because me and my client knew from reputation that the judge that we had was likely going to be favorable to our arguments considering the particular set of facts that were in that case. So we chose to go non-jury. That played into the analysis and it worked. And it was really a great feeling. But sometimes you have a judge who's a straight up killer. We joke that some of these judges are prosecutors, and it feels like the defense attorney against 2 prosecutors, because the judges some of these judges will go out of their way to support what the prosecution is trying to do, and me and my clients can feel like our rights or concerns are being ignored. But that's what happens when you've been accused of a crime. Okay, it's a terrible process. But there are a lot of judges who I would say are very fair, that come down right in the middle, and there are some defense-friendly judges. But overall, in the criminal realm, you're going to see judges who either try to be fair and play the line, or they lean towards the prosecution. And the reason for that is none of these judges want to be the one who releases someone and then that person goes out, commits some heinous crime, and then that judge's name is in the newspaper or on the evening news. So the judge can make a massive, massive difference. And that was another difference. So these 2 cases, and I'm thinking out loud here, the one that I took to trial, the similarities between these 2 cases were actually factually they were similar, and each person was facing at least 5 years in jail. So their possible sentence was high. But this case, the strength of the facts was a little more favorable to me and my client, and the judge was more favorable. Whereas this case had some more negative facts and a unfavorable judge. So that led us to take a plea on this case, where my client avoided even though we could have won, he avoided a possible 15 to 30 year jail sentence. He's gonna do some jail for sure now, some prison time, but he's still young enough that this is not going to impact him. He's going to get out, and he's going to be young enough that he can still turn his life around. So these 2 cases, back-to-back weeks, they've been dominating my time lately, and I had some of these thoughts about it. Again, one of the biggest the clients say to me all the time, and it really tugs at my stomach, is just, it tightens my sense. They say, "This is my life. This is my life." And it makes this job really hard. It's also humbling. It's very humbling because I'm out there. Again, they may or may not have done something bad. They may have done something bad in the past. They're not great people, but they're still human beings. And they put their lives in the hands of criminal defense attorneys. So, public defenders may get a bad rap, but man, are they out there fighting one of the hardest fights that are being fought out there in society. So I got all the respect in the world for every public defender or any attorney who takes on pro se cases or court appointed cases. Much love. So plea or trial, those are the three largest factors that you're going to encounter: the strength of the case, the possible sentence, and the judge. You want to know how strong your case is before you decide to go to trial, or at least get the best sense of it that you can. You want to know what the possible sentence is before your client goes to trial, or how much money is at stake in a civil case. And you want to know who the judge is. Those three things are so big. One more thought. I was talking about the extremes. So sometimes you have no choice but to go to trial. So, for instance, when an individual is accused of homicide and they're facing 20 to 40 years in jail, the prosecution may not even make an offer. Okay, so sometimes it's off the table. You know that you're going to go to trial. Okay, and then sometimes the penalty on something can be so low, or the offer so good, where the case goes away, they pay a little bit of money. Okay, you're gonna you're gonna take the deal, because some deals can just be so great. But sometimes your hands are tied. If your client, for instance, in Pittsburgh, there's been a couple of mass shootings in this city, as in many cities across the country. But several years ago, there was a shooting with 3 police officers were killed in the line of duty by an individual. And the prosecution in that case, there's no offer is going to be made. I mean, the individual could just plead guilty and go to jail for the rest of their life, or they could do a trial and likely be convicted and go to jail for the rest of their life. When the offer is life sentence or life sentence, you have no choice but to go to trial. So that case went to trial. The one thing about trial that I would like to mention as well is, if you go to trial and you lose, you still may preserve appealable issues. Now, most cases do not survive on appeal, but if you sometimes on a procedural technicality, you can preserve your right to maybe get a new trial in the future. So that's a thought. That's part of the thought process. Again, you could put way more factors in here. Strength of the case, possible sentence, judge or prosecutor. I hope you enjoyed this episode of Joe the Lawyer. I went a little long today, 22 minutes. I'm going to try to keep it from 10 to 15 minutes. This was my pilot episode. Please subscribe, like, comment, and share. I got a Patreon below. Tune in for more. Thanks.